I'd like to call the June 22nd, 2023 Board of Adjustment to order. Madam Secretary, can I get a roll call, please?
Board Member Babcock? Vice Chairperson Baker?
Here.
Chairperson Keller?
Here.
Board Member Duval?
Here.
Board Member Nosalik? Board Member Finkel? We have 3 members. We do not have a quorum and cannot conduct business for the evening. We do have a few items on the agenda that do not require a vote, if you would like to proceed with those.
We can't approve the minutes of the meeting without a forum either, can we?
Nope.
Okay. And we can't do the finding of facts. So, next item on the agenda is a presentation by the City Attorney, Holly Dodge, from Lauber Municipal Law, LLC. This is going to be an online course to assist with the Board of Adjustments, board members. And here to speak about this tonight is Holly.
Thank you, Mr. Chairman. Ooh, that's way too close for my loud voice. Let's see if I've got. I have a PowerPoint to show you tonight. Thank you, members of the board. What I'm going to talk to you about is just kind of an overview of what the powers are of the Board of Adjustment and where those powers came from. Sometimes it helps to understand the basis of our work in regards to where it came from. I think they're loading the PowerPoint. Essentially what I'm going to talk to you about is the background information relating to planning and zoning, that the Board of Adjustment's authority, the Board of Adjustment's power, and the Board of Adjustment's judicial review. It was on there.
We have copies as well.
Okay. I just was waiting. 1 second. Is it up? There we go. Got it. Okay, so I just went over that. City code requirements for variances and zoning regulations. Little background information. In the beginning, there was a nuisance. And if you look back, way back before zoning became a need, the only way you dealt with the problem neighbor was when the problem neighbor came along. So when you're looking to buy the farm or the feed store, you didn't know who was coming in the property next to you, and that limited your ability to make decisions and have some confidence in the use of your property. And the example that we use is, it's okay to swing your arms around, right? I'm okay right here. But if I get up there in between two of you and I'm swinging my arms around, I might hit you. Then I'm a problem, right? So you don't know a nuisance until it comes around, which by then, we got some real problems. So that was the law of the land. Once the problem came, then we dealt with it, and that was it. So in the Industrial Revolution around the middle 1800s, we saw great buildings with lots of pollution coming in and a lot of tenancies that are multi-family. We saw fires because of those. We saw all kinds of bad decisions happening because of this growth explosion and the compression of people into one area. So because of that, along came a desire for planning. When we see we have problems, the first thing we look at is, how can we fix those problems? Oftentimes, it means we need to do a better job of planning. Did I do that? Okay. So, background information. New York City is where the planning came from. In 1916, they had the first Planning Enabling Act. So then about 12 years later, we had two model acts, the Standard City Planning Enabling Act, the SPEA, and the Standard Zoning Enabling Act, the SZEA. In that time period, after those two plans came about for standard plans, within a year, 48 states had adopted some form of them. So that shows how great the need was at that point to deal with the problems. And of course, at that point, we're starting to have vehicles, which became a whole nother issue. So in Missouri, statutory cities, the third and fourth class cities, Branson being fourth, have only those powers which are granted by the statute. The difference is home rule cities like Springfield, Joplin, most of the St. Louis area, some of the Kansas City area have whatever power the General Assembly can have as long as they don't disagree with the General Assembly. With the third and fourth class, us being fourth, we can only do that which they have given us the power to do, and that power is given in the aspect of zoning under Chapter 89. So in the revised statutes of Missouri, the RSMO, you're going to see all my sites being to Chapter 89. So let's get into it. Zoning ordinances are the enforcement tool to aid in having a comprehensive plan. The planning is big picture. What would we like to see? The zoning is how we regulate at a lot level how the allowance to do certain things occurs. Because of that, and that proactive as opposed to a reactive, which we were doing in zoning, there are certain situations in which we find things are not able to be resolved. So when cities first enacted their zoning laws, back in 1926 was the first Supreme Court case where the court said, yes, you cities have a police power for health, safety, and welfare. Not police power like I can arrest you, but police power in this is what's expected of cities. Cities are expected to have plans. Cities are expected to have regulations. And those regulations need to relate to health, safety, and welfare of the people. So in this situation, Ambler Realty had some property they wanted to sell for an industrial development. No surprise, right? And there were some people who didn't like that. And the city said, no, we have zoned your area non-industrial. And they said, well, I can't make as much money, right? Money's what it's always been about. Money can always be a factor. And the court said, no, the consideration is the health, safety, and welfare, the police power that's granted to cities. Because that power is granted to cities, it's appropriate to be within their power scope. So the famous village of Euclid, teeny tiny village, you know, we talked about how third and fourth class are limited, villages are limited even more, but you never know when the acts of these small entities becomes what everybody talks about. And anybody who's worked in the business of planning knows about Euclid versus Ambler Realty because it was the seminal and still is the seminal power and always talked about in the power of you as a board. Zoning authority, the summary of the sources, the police power, which is the overarching power within a city, the State Zoning Enabling Act, which is in Chapter 89, and your city zoning ordinances, which are for the city of Branson, Chapter 94, Articles 1 through 13 of the City Code. You also have adopted for your board, your policies and procedures, and they do have an aspect in how you make decisions and what decisions can be made. There is a constitutional limit. You cannot regulate out of any value. So if an ordinance goes too far, you have prevented any use, you have thus taken it. If I give you a candy bar and I open it up and I pull the bar out and I leave you with the wrapper, I really haven't given you a candy bar, right? So those are the instances when the court's going to say, no, you violated the Fifth Amendment. That's not the Fifth Amendment right to remain silent. It's the really important Fifth Amendment, which is the right to avoid the taking of your property without just compensation. And really what that means is you got to pay up, right? Doesn't mean you can't do it, you got to pay up. As a result, the Enabling Act provides for the Board of Adjustment to act as a safety valve. So that's where I talked about you have your planning, which is where we want to be. You have your zoning, which is what on a lot level we are saying you can be. And in between those two and the reality of what I may own as a lot can mean there's some cases where the rule doesn't make sense at that lot level. And so thus becomes the Board of Adjustment. The Board of Adjustment is an overarching quasi-judicial and legislative entity that makes decisions to ensure that there is a way, a mechanism in that quasi-judicial to provide the relief for an applicant who is unusually situated, but always must keep in concept the spirit of the zoning. So, the Missouri Revised Statute, Chapter 89, grants to all cities the power to zone. So it says you have the power, you don't have to zone. But if you do zone, then it goes into 89040. It sets forth the purpose of the zoning, which is to conform to a comprehensive plan. That's the what do we want, to provide for safety, adequate light and air, avoid concentration of population and overcrowding, preserve features of historical significance, etc. These are areas where the courts have said, and that's why the statute also reflects that. These are considerations that must be part of those decisions. Regulations are to be made with the character of the district, suitability of uses, conservation of property values, and appropriate use of the land. In 89080, it requires that if a governing body chooses to have zoning, then they must have a Board of Adjustment. It's a must. So you may have zoning, but if you have zoning, you've got to have a Board of Adjustment that's empowered in making those practical resolutions to the challenges between those set of rules and what the reality is of a particular situation. Board of Adjustment may determine and vary the application of zoning regulations in harmony with the general purpose and intent as described in 89040. You must elect a chairperson to serve a term of 1 year, and the appointments are for a term of 5 years. In the basics of the Board of Adjustment, you're found again in Chapter 94, Article 12 of the City Code. The board is comprised of 5 members. You need 3 for a quorum. Need 3 members for quorum, and the board cannot conduct business. 4 to vote yes to approve a variance. So that's why tonight we didn't have 4, so we can't make any votes in regarding to the fact finding. All testimony, objections, and rulings shall be taken down by a reporter employed by the Board of Adjustment. So we have to have a reporter, a court reporter present to take that information when we have the hearings, not for things like this, not for things, approval of minutes and those aspects. So that's why you'll see them do some things, but not everything. The chairman presides over the meeting and has the inherent power to control the conduct of the meeting. You can impose reasonable time limits on testimony given in a public hearing to ensure the efficiency of the proceeding. That's a little bit of an area that everybody's being challenged with now, how long and how to limit and how to balance that input versus otherwise. As long as it's not content-based, that's when you get into when you say, I'm going to limit you because I'm tired of hearing about this subject, right? Or I'm going to limit you because we've all beat this dead horse. Then you're talking about the content of what they want to talk about, and now you're affecting free speech because we're a public forum in allowing that speech. So you can have a rule, and that's something you may want to discuss, that I know is something that the Board of Aldermen are discussing, and a lot of the cities are talking about now, how to balance that need. Yep.
Holly, in the past, in our documents, we've always had a time limit that was brought up and imposed on the audience at all the previous ones
And-
I can remember.
And you are aware that that's been around for a long time, and you've probably all seen on TV what happens when people go beyond that, right? So therein lies the rub. And therein lies, well, what do you do, right? Do you set a 2-minute time limit and they talk for 4 minutes and that's when you say go? And how do you say go? So that's the problem, and that's the challenge we're seeing across the nation. When a person chooses not to comply, is where we're seeing a bigger challenge. But just something to kind of think about in regards to that. The other is when you do conduct all of your meetings, you want to make sure that the chairman controls the conversation. I ask you for permission to speak, you grant me that permission, but you're granting me the permission to speak to the board, then you can ask the question to the staff. When that gets out of hand, that gets to be a problem and a challenge. So that's a big burden now, unlike what it used to be for the chairperson. 89090, Board of Adjustment Powers. They hear and decide the appeals, hear and decide matters as required by local ordinance, and when an appeal is brought before the court to vary the application of the ordinance's requirements, a variance, if there are any practical difficulties or unnecessary hardships. That language comes from the case law. You must find either that there's a practical difficulty or an unnecessary hardship before granting that variance. So that has to be a part of all of your considerations, and we'll talk a little bit more about that in a few moments. You always have to look at whether or not it's in the spirit of the ordinance. So you have to still find a way to craft and massage that. You can do that in having restrictions, and we'll talk about that later on, but that's a really important aspect of your decision-making, is that it's in light of the spirit of the ordinance. You have to consider public safety and welfare. That's one thing that you have to discuss and make part of your fact findings. And the result must do substantial justice. So you'll see in those proposed fact findings all of that magical language and something that you want to derive in the meeting, in the hearing in regards to a variance, that you've considered those aspects and how you've considered those aspects to be able to uphold your decision making, because again, you're quasi-judicial. Area variances are what you guys allow, which are bulk, also called bulk variances. That is determined by, it must be based on a practical difficulty. So you're varying from the zoning ordinance because it's practically difficult for that person to comply. The problem has to be unusual or peculiar. Your ordinance requires that it be peculiar. All of this comes from 94-154-D2A. You have to look at whether or not the condition is not personal or acted upon by that owner. They can't create their own problem and then come to you and say, now here's what I want you to do. You have to, these are all the considerations you must have. The practical difficulty can be, but do not have to be, due to physical characteristics of the property. It can also be for other reasons, but the obligation is always on the applicant. Even though it's processed in terms of usually whoever the applicant is or the requester of a judicial agency, they go first. But in these types of hearings, your staff goes first because they give you all of your information. And so in giving you all that information, they're not really making the case. The case has to be made from the applicant. And that's why recently you've seen that they've changed their forms to reflect what these qualifiers are that I'm talking about for the practical difficulties. And there has to be the finding that it is based on a practical difficulty. The use variances are not provided for you guys, so that's not within your purview because the code did not provide for that. Could they? Yes. If the Board of Aldermen made the decision they wanted you to do use variances, they would have to add that into the code. These are variances that allow a use of property that is otherwise prohibited, and that burden is unnecessary hardship. That's what they have to show. It's more stringent than a practical difficulty. The relief must be necessary because it's the unique character of the property. It has to be related to the property. The land in question cannot yield a reasonable return if used only for the purpose allowed in the zoning district. The owner's plight is due to a unique circumstance, or in what we have as a standard peculiar, and not a general neighborhood condition. And again, it cannot be self-created, and so they always talk about it cannot be self-created. The discretion in making zoning decisions. Zoning decisions generally fall in two categories, and we've kind of talked about that: legislative and quasi-judicial. The legislative is defined by the police power. That's Euclid, where they say that health, safety, and welfare. It is done by elected officials. And an example is an alderman enact or amend a zoning, rezone an area, or set standards for exercising discretion. Quasi-judicial is defined by state statute and our local ordinance. Key point to that is that you only have the power that is given in the statute. So you couldn't give a use variance because that's not given in the ordinance, even though it's provided in the statute. It again is done by officials appointed to perform a statutory function. For example, the Board of Adjustment makes a decision regarding how the application of the legislative decision has affected an individual. So it can also be that you don't believe that the interpretation of a particular ordinance means a particular thing in regards to zoning. So that's another aspect of the quasi-judicial. The discretion authorized by the state statute gives it to be either a practical, and that's in 090, either a practical difficulty, which is what you guys use for the area or bulk, or an unnecessary hardship, which is just for the use, which we don't have. Okay, City of Branson, your particular code, 94-155D2, variances. The conditions that govern applications and procedures to authorize, upon appeal in specific cases, such variance from bulk or area regulations. So that's where, if they wanted to change it, they would have to change that particular and say that it's also from use. But because it doesn't give you the power of use, you don't have that power. So that's why we only have the practical difficulties. Conditional variances. The Board of Adjustment may impose any conditions, safeguards, and restrictions that it believes are necessary to reduce or minimize potential injurious effects of a variance. So even when you say, yes, this variance should be granted because they met all the requirements, but we want to make sure you only do it in this aspect, okay? So it can't be a timed aspect because a variance runs with the land, and we'll talk about that, but it can be, you can build on, but you can only build on, you can build out, but you can only build out 5 feet. You're asking for 6, we're gonna give you 5, right? So when you do that, you need to show why you're making that decision. And that's really important in both the discussions, the questions asked, so that's the record that it's based on, that's how we'll know that you appropriately considered this, and on your fact finding. So that's why it's important that the fact finding articulate all of the things that were discussed in regards to what mattered to the board as a whole. Lasting effects, written in stone. It lasts until the zoning is changed. So it runs with the land, not the person. So you're not granting a person or a entity a variance, you're granting that property a variance. So as long as it's allowed in that zoning, that variance will continue until the zoning changes. 89-110, judicial review of decisions. So any person can be aggrieved, who is aggrieved by this can bring a claim, meaning the neighbor. right? The neighbor's aggrieved by your decision-making, and they have to do so within 30 days by a petition for writ of certiorari, which sounds like I've got something in my mouth, so we always say writ of cert. And that's where the court reviews it based on the record, and that's why it's so important that the record and the conversations that are had and why they've changed some of the procedures in the application process so that we have that information on the record. So the application specifically asks each of those conditions, so that's what the applicant is telling you. So even if it doesn't get discussed, those exhibits are attached to that decision-making because that's part of the record. It was submitted, the PowerPoint by staff member is submitted for your consideration. So all of those things then are part of the record and can be looked at by the court, which is why it's so important that all of those things are made part of the record and submitted. Implications of judicial review. It's the applicant's responsibility to prove every element of the variance requested. So if an applicant leaves that blank in their application and never touches on the fact that it was of their own accord, and they don't answer the question of whether or not they were in that situation because they created that situation, then you could find a denial of that variance because they didn't meet that requirement. Now, you can always ask them, hey, you didn't answer this, I haven't heard you talk about this. That helps to make a fair record because really what your task is finding that middle ground between what the zoning is in its cold, hard words and the reality and practicality of how that person's property exists. Implications of judicial review. The discretion is granted to the Board of Aldermen, the Board of Adjustment in making decisions depending on weighing the effects that the variance will have on the spirit of the ordinance. So that's always part of what you're considering. Also, the effect of public welfare, the effect of public safety, the effect of public health. So we always talk in terms of those key words because those are your responsibilities. That's what's put on your shoulder or put in your backpack in the more youthful terms. When reviewing the board decision, the court looks at the record. So that's why it's super important that we have this clear record of what decisions you are making and how they're based on. That's why we have the aspect. That's why you guys like to have me come visit so that I can assist in that drafting and finding of facts so that we relate that to that court. So it all builds on top of each other and it all has a basis in minimal requirements that show in the end a practical difficulty. And that was not very long, so I think I made it as quick as I could. I will note to you that we have now opened an office in Springfield. We're super excited. It's at the corner of National and Sunshine. And I thank you so much for your time. Does anybody have questions?
I do have a question.
Yep.
In the notes from the last meeting, there was a note that we should not consider other properties in violation of the ordinance when considering the granting or denial of a variance. I didn't see anything in the presentation tonight, but specifically for the instance that we heard last meeting, I did personal research. There were at least 10 properties that I found in the entertainment district that also were of similar standing to the code. So can you speak to that real quick?
So there's legal non-conforming use, and some of you maybe have heard that term used in the colloquial and of course now not PC way of grandfathering. So it's legal non-conforming use. So you can have a use, and Branson has been an entertainment district for a very long time. You're not new to this stage. So you would have uses in areas that then when they changed the zoning or became more defined in the zoning. So 30 years ago, we never looked at short-term rentals, right? VRBO, Airbnb was not an issue. Now it has. So there's different factors that have changed and modified zoning. Zoning is a kind of moving beast. So some of those could exist because of legal nonconforming uses. And the ordinance itself says that you can't look at that. So that's where that comes from. It's within the actual code. However, it's also because we change zoning because of the direction we want to go in our planning. And so if we always base it on what is there, we don't grow and we don't change. So if we say, oh, but 4 others have it, so I should be able to, that shouldn't be the consideration because you're violating the spirit of the zoning. The spirit of the zoning is to limit it for a reason, whatever the reason is. And so those are all the reasons, I gave you 3, as to why you can't say, oh, there's a lot of others. Or we'd never get compliance in the future to accomplish our plan. Does that make sense?
It does make sense. It just is the burden on the board to educate themselves on what properties may have been legal
non-conforming uses. It is not, because that is not in the record.
Okay.
So the record really is that which is presented. Should you have done that research and that was a part of, that's your aha moment, and then you could say to staff, when staff is presenting, Mr. Calusi, is there a lot of legal nonconforming uses on that particular, within that particular zoning district? Because it's not the block, it's the zoning district.
Right.
So you can ask that, or you can say, I've done the research, I knew it was about this, so I did the research, so you're kind of presenting it. The burden is on the applicant.
Sure.
However, because the burden is on the applicant and because we're working towards our plan, our goal, and to comply with our zoning, we wouldn't consider that because it has to be for this particular lot that is addressed in front of you. And you always have to, because of the legal nonconforming use, I clearly am in violation, but I'm an allowed violation. Because of that, however many there are is irrelevant. And that's why it's in the code, because we would never transform into that which is planned. There are lots of times you guys will see, especially because of all your growth and with changes in what's popular, right? What type of living circumstances or entertainment circumstances. And there's lots of things that drive real estate, and those change over time. If the zoning and the planning want to be in their most efficient fashion, they can't look back, they look forward. And legal nonconforming uses are saying, well, it wouldn't be fair for us to change you up now. But if you change the use, then you come back in. If you change the area use, the variance of an area, then it wouldn't be fair. Does that kind of make sense?
Understood.
So you certainly, one aspect of your question I want to hit on, which is it our responsibility to educate them? It's always helpful as a board serving a community to help an applicant understand where you come from in making that decision. So that's where the discussion and that power that you guys have on your shoulders. It's a big power. And we've seen some boards of adjustments that become the yes. I don't know if all of you are familiar with Ed McMahon, everything Johnny Carson said, good job, right? We agree with everything. It can't be a board like that because we would never get to our planning or our desired zoning. But that educational piece is very helpful because you guys are the learned. The staff is your experts who can explain to you, and I know you guys know that because I've seen you ask questions very detailed, and they always know the answers. That aspect of it is here. You're very blessed with having all of that. You guys are blessed with already knowing you're way ahead of a lot of groups in that fashion. But you probably have applicants who don't have that knowledge. So there's that, you know, big bad government, you're in an elevated stance, you're making a decision about something I want, I've spent money, I've done effort on it, so it helps in educating that person. So there is that aspect. There's a long attorney answer for you.
Thank you.
So much for getting done quickly, right? Ugh. Thank you for your attention, I
Hey,
appreciate
Holly,
it.
over in the past, on many times, we've had applicants come in, and they bring in either photographs or additional copies of something they wanted to present. And it was always imperative that we added that into the history of the meeting of that night. Plus, we always added the Missouri statute number 89 plus city code ordinance at the same time as reference.
Yes. And you are created by the city code, so that would automatically be part of it because that's where you're making the decisions, that's where your authority comes from. But yes, it's very important, and staff and I've had conversations about that. We have to make sure that it's in the record.
Right.
So sometimes they'll say, oh, here's a picture, and they kind of show it like here, or here's a map or something. Those have to be marked and marked as noted as being accepted
Yep.
because you are the judiciary. So yeah, you've got to kind of regulate, and I know your staff helps with that to make sure that it's submitted. That's why when Mr. Calusi gives his presentations, he says, I'm submitting the PowerPoint because it has so many pictures and so much information.
Thank you.
Thank you.
On our second discussion tonight, we are going to review a possible change to the meeting time for the Board of Adjustments. Mark, do you want to give us a discussion on that?
Thank you, Chairman. So, as you would be well aware, there was very few need of Board of Adjustment meetings over the previous 2 years, and now here we have 3 meetings in a row, so we're kind of getting our exercise legs out in front of us. But why I bring up the context of that is since that time, when you were more actively meeting back in like 2021, 2020, or earlier than that, the Board of Adjustment, the Board of Aldermen, and the Planning Commission all would have met at 7 p.m. in the evening. Since that time, the Board of Aldermen has moved their meetings to a 6 p.m. time slot, and then subsequently, the Planning Commission has also moved their meeting to a 6 p.m. time slot. So I just wanted to bring that particular item to your attention, not necessarily saying that you should move your meeting to the 6 p.m. time slot, but it is within your purview to change whatever time slot you would want to have for the meeting. I've seen other areas, for example, have their meetings immediately after the end of the afternoon, like say 4 p.m. I personally, I don't want you to make any decisions based on my decision, even though I will give you my opinion. I think like a 4 p.m. time slot would be optimal for the fact that the City Hall is still open at that time, so there's no issues with doors being locked. Public can come in. Not only that, obviously you can get in and not have any concern about the doors potentially being locked. It helps with like IT staff in particular being able to be at the meeting, but just something to potentially consider. But I will say that the nice thing is that the bylaws that you have specifically mention that for the adjournment of meetings, it says that in the event to which the Board of Adjournment is to adjourn its meeting to a certain hour on another day, a specific date, time, and place must be set by the board prior to the regular motion to adjourn and the meeting to be adjourned. So the meeting to be adjourned, excuse me. So point with that is that, ultimately the meeting, is it the procedures that's mentioned, the time frame? Rules and procedures mentioned the actual 7 p.m. time frame, so that would actually need to be adjusted, or maybe it was the ordinance.
There is no time frame on either the ordinance
Okay.
or the rules and procedures.
So with that said, you would definitely have the ability to adjust that time to whatever would suit your board to the best of your ability to convene, and seeing that obviously we have many of your members that aren't here right now. I don't know if it has to do with the time, but surely the time of year matters as well. But I at least wanted to bring that to your attention that obviously the Board of aldermen and the planning commission have adjusted their time frame where they had been meeting regularly at 7 PM in the evening. So at least wanted to put that in to your attention. I mean, certainly we have legal representation that, gracious enough that Holly's been able to attend our meetings. So, even from that standpoint, those kind of considerations that I know that staff, for example, we've been getting used to having lots of evening meetings, but I know that you guys, I don't know if you would like to be home in the evenings and just come here like earlier in the afternoon and go straight home after this, but at least wanted to present that to you to see if you want to have any discussion on that. So,
Can we have a vote on that tonight, or do we have to have a forum?
no, you actually can adjust that right now. Yeah.
We have to have a forum to be able to vote on that.
No, you don't have to vote on it. You just have to state the time for the next meeting.
Does anybody have any questions?
I'm okay with 6, but any earlier than 6 is difficult for me.
Well, the 6 is a good time because it allows the person who's working till 5 or 5:30 to attend the meeting. That's why it's set kind of like that. So I'm fine with it.
I was wondering for years why we met at 7 and
Yeah.
everybody else met at 6.
6 is fine, and I guess we'll put that on the agenda for the next meeting and take a vote and finish that up.
Technically, Mr. Chairman, when you adjourn today, you set when the next date is and the next time. So we would adjourn, should you have the vote, and adjourn this meeting, which did no business, and reconvene, and you state the date and the time for the next meeting. And so each time, that's how you notify the public, and that's when we notify the public. If you want to add that to your procedures, you can add that. That would take a vote. But you can just do that as a matter of course in the announcement of the next meeting.
So in just the clarity, I think that adding that to the schedule provided to the chair and vice chair, it would be good to just add that as a line of stating the next time and place.
Okay, Mark, you have anything else for us?
No, and just to note, if you were to use the previous schedule, the meeting would next be scheduled for July the 27th. That would be a Thursday. So just wanted to at least put that on your radar. But
Okay.
thank you. No, that is all I have.
Anybody have any other questions? No. Okay. Thank you, Mark. At this time, I'd like to schedule the July 27th meeting, Board of Adjustments, to start at 6 PM in the evening, and so be noted in the notes.
So noted.
Thank you. Okay, this concludes the items scheduled for the Board Adjustment meeting. I now entertain a motion to adjourn.
Motion.
I have a second.
Second.
I have a roll call, please. A call for vote.
Board Member Baker, or Vice Chairperson Baker, I apologize.
Yes.
Chairperson Keller,
Yes.
Board Member Duval.
Yes.
Okay. Meeting adjourned at 7:50 PM.